Welcome to you all, both here in the room and online. The first panel of today, which is the fifth panel of this wonderful conference, is on the Pact, the new Pact and externalization. Before I give the floor to the speakers, I would like to sketch the broader picture of this topic. And I want to do so using the recent collapse of the Afghan government as an example, as a concrete case of what might happen. So I build on what Philippe said yesterday. The collapse of the government supported by the West just a few days ago has not yet led to a major refugee issue in Europe, but it might do so. And the Justice and Home Affairs Council responded to that in a statement of the 31st of August. And this statement illustrates, in a very concrete situation, the failures of the common European asylum system that became evident to everyone in 2015, and it had been diagnosed well before 2015 by the members of our network and by many others. And these major failures are threefold. There are three of them. First of all, the common European asylum system, leads to an unreasonable distribution of responsibilities within Europe, and partly as a consequence of that, there's no harmonized legal practice among the member states. The second major failure is an excessive reliance on the external borders, which results in tensions with international law obligations and also results in dire humanitarian situations just outside and just inside the borders of the European Union. The third major failure and structural failure is the reliance on third states to implement European migration policies while these policies do not serve the interests of those third countries. Because the member states cannot agree on ways of addressing the first problem, the internal problem, they rely almost exclusively when faced with a potential problem on external borders and on third countries. As a result of these failures, which are not, let's say, conjunctural, but which are written into the structure of the common European asylum policies, common European asylum system, European policy is predominantly coercive. That's evident at our borders, where there are, right now, massive, routine, daily forms of refoulement, which for some reason we don't call by their name anymore, but we call them pushbacks, which are at least tolerated by European agencies and not just by Frontex. There are pullbacks, there's culpable non-rescue at sea, for third countries also there's coercion. The EU uses the disparity in economic, political and military power in order to force third countries to adopt its policies. And that's an approach which works best with authoritarian governments such as Turkey, because there the voice of the population doesn't really make it to policy making, and it has less of an impact. The coercion of the EU has less of an impact, is less successful with governments that are more sensitive to their population, such as Tunisia. Now, the proposed pact continues to rely on three main pillars when it comes to externalization, and these pillars have been and will be, according to the pact, first of all, addressing root causes of irregular migration. Please notice that refugees have been subsumed under irregular migration. Secondly, return and readmission of migrants who don't have a residence right in the EU, and that includes not only nationals of the countries who are supposed to readmit, but also non-nationals of those countries who transited through these countries. And thirdly, legal pathways. Now, let's look at these three pillars in the case of Afghanistan. First, root causes. And when we're honest, we have to admit that the root cause of the potential problem that Europe is faced with is the failure of the US-European intervention over the past 20 years. This intervention resulted in 2 decades of warfare and not in a stable state. Now one might say, well, it's a bit too simplistic because it's not accurate to blame this entirely on the West. because there was a history before 2001. There was a Soviet invasion in 1979 in order to keep going a communist government that had taken office in 1978. In order to counter this invasion, the US and Europe supported groups opposing the Soviet invasion, among which the Taliban, and this also resulted in protracted warfare. And this is a phenomenon we see more widely. The single most important root cause of forced migration are failed foreign and defense policies which the European Union, the EU and its member states at the very least support. Think of Afghanistan, Iraq, Libya, and the intervention in Libya then resulted in the destabilization of the Sahel as a whole, and proxy wars where the West supports its allies but not sufficiently to end the conflict, such as in Syria, Yemen, and Somalia, which also results in protracted warfare. So, to conclude on root causes, we may have to conclude that the EU is not addressing them, but contributing to them. The second pillar is return and readmission, and more generally, containment of people, of refugees in the region. That is the policy instrument that the EU seeks to use responding to Afghanistan. However, this is unlikely to be found unreasonable by countries. This is unlikely to be found reasonable by countries like Pakistan and Iran because they have experience with these policies over the past 40 years. The EU and others have failed over the past four decades to fund more than half of the funding needs of UNHCR. And the EU and the international community more widely has equally failed to resettle more than a homeopathic number of Afghans. For your information, last year, globally, so the entire international community resettled, to be precise, 621 Afghans. And I calculated this for you, that is 0.03% of the global Afghan refugee population. Because of this half funding and homeopathic resettlement, Europe is simply not a credible partner for Iran and Pakistan, and it will take years before the EU will become one. So, the last pillar is legal pathways, and that is, of course, precisely what the EU does not want at all. It's pretended to be a pillar, but it's a pillar that the EU mentions, and then basically the thing is not to have legal pathways for refugees from Afghanistan. The EU is incapable of rescuing the people who made their intervention possible, and as Philippe also mentioned, the statement of the 31st of August says that support could be provided, support to the region could be provided in the form of resettlement on a voluntary basis. And the code words here are could and voluntary. So this basically means the EU says we are not going to do anything more than the homeopathic forms of resettlement we are doing right now. In the case of Syria, it took about 4 years for the refugee problems to reach Europe. In 2011, the war started, and in 2015, Europe really had a problem. If that is a measure to go by, then there may be some time, that we may have some time, Europe may have some time to think of something better than Europe putting all its cards on a coercive externalization. So I think this is an appropriate moment to discuss what the European policies have to offer on the point of externalization. I will give the floor to the speakers in succession, and I will introduce them as we go. The first speaker is Violeta Moreno-Lax at Queen Mary University. And Violeta, rumor has it that you have been promoted to a full professor, so I hope you can confirm that rumor. And I give you the floor for 10 minutes and not more to address the extraterritorial reach, or the jurisdiction aspects of human rights. Violeta, the floor is yours.
Thank you very much, Thomas. I do have a PowerPoint. I do confirm the rumor. I'm very grateful for you to
Congratulations.
Thanks a lot. I do have a PowerPoint. So let's wait for it. There we go. So thanks a lot. I'm going to set my clock now. So for the 10 minutes, starting now, thank you for the invitation to present on the extraterritorial reach of human rights obligations. Next slide, please. I'm going to be approaching this question, the legal criteria that trigger extraterritorial human rights duties for the EU and the member states. And I'm going to be approaching it from two different perspectives, from EU law on the one hand and international human rights law on the other hand. So taking into account the EU Charter of Fundamental Rights and the European Convention on Human Rights. Next slide. Under EU law, the situation should be quite clear because the constitutional setup appears to be unambiguous. Articles 2, 6, and 21 of the EU Treaty make for a pervasive requirement for the EU and the member states to comply with fundamental rights in all spheres that are governed by EU law, including the area of freedom, security, and justice. And within this setup, the Charter of Fundamental Rights is the primary reference point to take into account. And one element to bear in mind is that the Charter doesn't have a jurisdictional threshold to be activated. Why is this? Because the European Union is not a state, it's an international organization, and it doesn't possess sovereign territory of its own. So territorial notions and statal conceptualizations of when and how the provisions of an international instrument apply, such as this one, would be inadequate. What happens is that the applicability of EU law, it's what entails the applicability of the fundamental rights acquis guaranteed by the Charter. And I am reading from the case law of the Court of Justice of the EU, and particularly the Franson ruling. So this means that extraterritoriality is immaterial to the question as to when and how the Charter of Fundamental Rights applies. The Charter applies whenever EU law does, so that fundamental rights track all EU activities whenever and wherever they may be executed. Next slide, please. This has been codified in Article 51 of the Charter of Fundamental Rights, establishing that the provisions of the instrument are addressed to the institutions, bodies, offices, and agencies of the Union, and that would include Frontex, EASO, and so on, in anything and everything that they do. And also the member states when they are implementing union law. And in this regard, we should take into account that the wording implementing EU law amounts to transposing EU law, applying or restricting EU law, or derogating from European law provisions when that is allowed under EU law. And there's one specific codification of this obligation that I would like to draw attention to, which is Article 71 of the recast European Border and Coast Guard Regulation that makes plainly clear that Frontex interventions and any action by participating member states is subordinate to observance of the Charter of Fundamental Rights. And this includes when they cooperate with their countries and when that cooperation takes place in the territory of those third countries, be it Libya, Turkey, you name it. Next slide, please. What happens, however, when the situation doesn't fall to be governed under EU law? Is that the end of the story? No, international human rights law kicks in. And in particular, for our purposes, the European Convention on Human Rights, which is subordinate to the establishment of jurisdiction. Jurisdiction here works as a threshold criterion. Without the establishment of jurisdiction, there can be no establishment of responsibility for human rights obligation violations. And in this situation, according to the case law of the Strasbourg Court, jurisdiction is considered and contextualized as being territorial. So territorial jurisdiction is presumed as the general rule, but any exercises of extraterritorial jurisdiction need to be proven and demonstrated in the specific case. And the court in its case law has developed two specific standard tests that have been allowed the court to determine when an exercise of extraterritorial jurisdiction has happened. The territorial model, according to which control over an area or premises abroad would trigger ECHR obligations, and the personal model, according to which state agent authority over a person abroad would do the same thing. Both tests, however, focus on the notion of effective control. Next slide, please. And the problem with this is that there is no clear definition of what is effective control. Is it only de facto control? Is it only exercises of direct physical power over persons or territory abroad? What happens to forms of indirect or contactless control, for example, through drone surveillance or a maritime blockade? And what happens to intermeshed elements of de jure authority prescribed under public international law, like search and rescue obligations? The answers to these questions are unclear because the court has followed a piecemeal approach, leading to gaps and inconsistencies. Next slide, please. This is why in my scholarship, I've proposed an alternative functional model, which is being tested in a case currently pending in front of the court, which is the case of SS and others versus Italy, brought with the Global Legal Action Network in association with other organizations. And this functional model, what it proposes is to take account of all manifestations of public powers normally exercised by a sovereign government, through which state functions are discharged. And this can be through de jure or de facto actions or omissions, which need to be considered in conjunction. Whether these functions, the status functions, are executed through legislative, executive, or judicial activity. Next slide, please. So coming to the case that it's being piloted in the court, SS and others versus Italy, this offers a good example of a functional approach to jurisdiction. The case concerns a pullback operation of a migrant dinghy carrying 130 persons who were forcibly returned to Libya by the Libyan Coast Guard from the high seas on instructions from the Rome MRCC, delivered on a cooperation matrix, which is quite complex, and I would like to unpack, and that facilitated and actually allowed for the intervention of the Libyan Coast Guard. Next slide, please. What I proposed under the functional model, and as I said, is being tested in the case pending before the court, is that we take into consideration not only elements from the personal model or elements from the territorial model, which are the two tests that the Strasbourg Court has accepted so far for the establishment of extraterritorial jurisdiction, but that we look at all relevant jurisdictional elements in combination from a holistic perspective. And so, focusing on the personal model, the orders delivered by the Maritime Rescue Coordination Center from Rome, which produced effects outside Italian territory, but were adopted within a territorial scenario, within Rome, where the MRCC is located, producing a predictable result and sufficiently proximate repercussions, we claim is jurisdictionally relevant and exclusively attributable to Italy. So that on its own should already trigger the responsibility of Italy. But there is more, and there are elements from the territorial model which are also of relevance to this case. There are the military, economic, and political support that has been delivered to the Libyan Coast Guard and the Libyan state through equipment, training, financing, through funding that comes from the European Union Trust Fund for Africa and a dedicated Africa fund constituted by Italy in August of 2017. All of that generating decisive influence on how the Libyan Coast Guard operated in this particular case and overall. And on top of this, it has been acknowledged by the Tribunale di Catania in a decision of 2018 that the Italian Navy controls the Libyan search and rescue response in the central Mediterranean. How? Through its Operation Nauras, constituted as an extension to Operation Mare Sicuro, deployed since August 2017 on the back of the Memorandum of Understanding of Italy-Libya of February 2017, according to which Italian authorities participate in the command and control chain of the Libyan Coast Guard. So there is a direct operational involvement of the Italian state within the Libyan Coast Guard structure, so that the Tribunale di Catania has declared that the Libyan Coast Guard operations happen under the aegis of the Italian Navy. So all of this put together should lead us to conclude that Italy exercised jurisdiction under a functional approach, and that should be sufficient to establish is responsibility in this particular case. Next slide, please. And with this, I conclude. Coming to the original question that was asked for me to address, what are the legal criteria triggering human rights obligations in extraterritorial scenarios for the EU and its member states? To wrap up, I think the situation under EU law is clear. Jurisdiction has no bearing. It's a non-notion within EU law for the triggering of the fundamental rights acquis. The fundamental rights acquis follows an aterritorial understanding of fundamental rights obligations. Whenever a situation is governed by EU law, that means that the Charter of Fundamental Rights applies. If a situation is not governed by EU law, then the ECHR becomes applicable and jurisdiction becomes relevant. Because the case law in that regard is not consistent or principled, what I am proposing, the quote follows, is an approach of functional jurisdiction as proposed in the SS case, whereby any exercise of legislative, executive, or judicial functions by state through de jure or de facto actions or omissions be considered holistically in every given situation. Next slide, please. Thank you very much for your attention. And if you would like to know more about this functional approach, the references are listed on the slide for you to go further. Thank you again, and I look forward to your questions and the further discussion.
Thank you very much, Violeta, for doing so much and such complex stuff in 10 minutes. The next speaker is Akis Papastavridis from Athens University, and he will address let's say, the Italian policies and practices towards a private search and rescue on the Mediterranean. Akis, the floor is yours.
Thanks so much, and thanks for the very kind invitation. I wish I was with you in Brussels. I hope next time I will be there in person. Now, I was asked to address actually the issue of the 2020 Commission recommendation on this cooperation between SAR NGOs that they are doing SAR activities, search and rescue activities, and states, and also the Italian Code of Conduct that was actually concluded between Italy and these NGOs. Also, was a very interesting application for a preliminary ruling by the European Court of Justice that was launched on 8th of January 2021 with respect to the potential port state control over vessels like the Sea-Watch in Italy. So these three are the main focus of my very short presentation today. I will try to address some of these issues. I cannot do all of them, of course, from the viewpoint of international law of the sea and search and rescue, the law concerning search and rescue at sea. So this, my focus will be only law of the sea and not human rights law or EU law. Now, the first issue that was also it's part of the discussion, the Italian Code of Conduct, and it's very interesting. It's the issue of entry to Libyan territorial waters. If NGOs vessels that they are operating in the Central Mediterranean can enter or cannot enter into the territorial sea of Libya. Under the Italian Code of Conduct, this is not a case. They should not enter. There's a commitment not to enter there. Now, under the law of the sea, there is the right of innocent passage, which all the vessels have. So in principle, they can enter into the territorial waters of Libya, provided they are engaged in innocent passage. Now, whilst they are innocent passage, they have to be a continuous passage and an expedited passage to the territorial waters of Libya. But there is under Article 18 of the Law of the Sea Convention and customary international law in this regard, there is an exception. You can stop in order to pick up rescue people at sea. So in principle, they cannot be actually stopped from entering into the territorial waters of Libya. Now, if they are taking people on board, however, they should actually cooperate with the Libyan authorities, right? So then they are subject to the jurisdiction of Libya and Libya immigration laws or regulations. And this is under Article 21 of the Law of this Convention. Libya, of course, is not a part of the Law of this Convention. However, all these are customary international law. And the next question, of course, is whether there can be enforcement jurisdiction from Libyan authorities, which is another, it is an issue whether they can be forced to actually disembark persons in Libyan ports. Now, the second issue is the issue of actually all these vessels having certificates or extra requirements that can be also subject to inspection at ports, like the case that is now before the European Court of Justice. Here we have to draw a fundamental distinction between state vessels and rescue units and private vessels. So if there is a vessel that is actually state-owned or state-operated, and it's exercising non-commercial governmental service, such as rescue services, but it's commissioned only to do this, right, by the state, then this vessel is considered to be a state vessel. So it's not subject to any inspection. It has immunities, enjoys immunities and privileges under international law, custom international law, and also there's the 1926 Brussels Convention that's still in force in this regard. However, the majority of these vessels we're talking, the NGO vessels, are not rescue units, as you know, it's provided for under Article 2.4 and 2.5 of the SAR Annex. They are just private vessels that they are actually operating on the high seas, and they are under, you know, they are exercising the right and their obligation, the duty to render assistance at sea under Article 98 of the UNCLOS and SOLAS Convention. So these vessels, this means on the high seas that they are just, they have a duty to provide services, rescue services, which goes hand in hand with the duty, however, to notify the responsible MRCC and cooperate with MRCC. Okay, this is also provided for in the Italian Code of Conduct, which is in accordance with international law of the sea. However, and this is very important for the present discussion, is they are cannot be ordered and instructed on the high seas to go to a specific place or not to go to a specific place. Because you have the flag state jurisdiction, the principle of exclusive flag state jurisdiction, it's only the flag state that can actually give orders to the vessel. More importantly, under the Italian Code of Conduct, and I was struck to see this, they are saying that, you know, these vessels shall also give information on their financing, give information, accept also law enforcement agents of another state on board. This is, under the law of the sea, preposterous to use this word, and excuse me, maybe it's a very hard word, because under the law of the sea, you know, there is only the flag state has these powers. You cannot, you know, board a vessel on the high seas without the flag state consent. So if let's say it's a Greek flag vessel and Greece gives consent on these activities by a third state, this will be lawful. But without consent, no party. No, you cannot board this vessel. And you're not also required to give information on your finance. Okay. Now, when these vessels are going to a port, right? In this regard, we have to, you know, because it's a private vessel, not public vessels, yes, they will be subjected to inspection under port state control, under territorial jurisdiction of the port state. However, when it comes to whether they should have other certificates or other requirements, as it is also the question before the European Court of Justice, and also the discussion, the you know, undergoing discussion with respect to this new SAR regime, I'm not so sure. Under the SOLAS Convention, Regulation 7, Paragraph 3 of the SOLAS Convention, which is, you know, applicable worldwide actually, though you have only the passengers vessels shall have a plan of cooperation with the appropriate search and rescue services. So there's some minimum requirement to have certain, you know, a plan for search or rescue. You have an obligation to cooperate with the MRCC, the Maritime Coordination Center, but no actually further requirements for more, you know, additional stringent, you know, certificates in this regard. And this could not only happen because, you know, again, the idea of the flag state jurisdiction kicks in. So there was a very recent decisions of the International Tribunal for the Law of the Sea and an arbitral award in the cases of North Star versus Italy and Enrica Alexi case in 2020, which actually reaffirmed the principle that, you know, there is an exclusive legislative and enforcement jurisdiction of the flag state on the high seas. So if you are in a port, like Italy did and Spain also actually did, if you're in a port and you say to a certain state, certain vessel, that you have to have more requirements rather than the requirements that they're provided for under SOLAS. So more stringent requirements for something for an activity that you do on the high seas and not in the territorial sea of Italy, but on the high seas. This will be a violation of the principle of exclusive legislative jurisdiction of the flag state. So in shortly, because also time flies, you know, you cannot, when a vessel goes at port, you cannot actually require the vessel to have more, you know, stringent qualification rather than this qualification that they are provided for under SOLAS. You can inspect the vessel, but you cannot have all these requirements in place. So to conclude, as I read the Italian Code of Conduct, and as it might be the best practice model that will be used in the future through the Council recommendation of the Pact, I see many issues with respect to the national law. The issue of the commitment not to enter into Libyan territorial waters is, for me, is a no-go. The issue of actually not to give information on the financing of vessels or to accept the law enforcement agent. Again, this is a matter of the flexible jurisdiction. And also when it comes to certificates, I think that the minimum requirement, if you want to commission these vessels and use them as a rescue units under Article 2, Paragraph 4 of SAR Annex, yes. But if they are private vessels operating and doing search and rescue activities, and they are actually asked by the responsible emergency when they are on the high seas, no, you cannot order this vessel. You cannot actually put this vessel on a higher level of compliance, as it seems to be the case by Italy right now. With these notes, I thank you so much. I'm looking forward to the question later on. Thanks.
Thank you, Akis, for taking us through these complicated maritime law issues that are so pertinent to the lives of people at sea every day. The next speaker is Nora Markard from Münster University, and she has. I'll permit myself a slight overstatement. She has kissed back to life the right to leave, which no one ever paid any attention to a couple of years ago. So please, could you share your reflections on that with us?
Yes, thank you very much, Thomas. I've also sent you a PowerPoint presentation, which I hope will make my points more easy to follow. Yeah, thank you very much. As you mentioned, I've been asked to talk about the external dimension of the Pact in relation to the right to leave. And Thomas, also have already outlined this external dimension and mentioned a few of the points that I'm going to come back to. Next slide, please. If we look at the explicit goals of these cooperation agreements with third countries, we can identify three such goals: to prevent irregular entry, to prevent the loss of life at sea, and to combat human smuggling. So this is basically the more palatable version of minimizing arrival numbers. Next slide, please. The strategy that is employed in pursuance of these goals is to immobilize or contain migrants in the country of origin or the country of transit. So that means to have those countries implement non-departure measures and pullback measures. Next slide, please. This quote of the Pact, from the Pact, is an example of this triad of goals. The Commission here calls for strengthened cooperation with countries of origin and countries of transit to prevent dangerous journeys and irregular crossings, including through tailor-made counter-migrant smuggling partnerships with third countries. I see that some things have skipped around on the slides. One of the non-legal instruments geared at addressing this issue is the new action plan against migrant smuggling that will be released soon. Next slide, please. A more up-to-date quote comes from Commissioner Johansson's statement on the situation in Afghanistan that Tom has already mentioned. She said, "We should not wait until people arrive at the external borders of the European Union. This is not a solution. We should prevent people from heading towards the European Union through unsafe, irregular, and uncontrolled routes run by smugglers." Of course, she then went on to call for supporting IDPs in Afghanistan, for supporting the neighboring host countries, and also for resettlement. And nobody, I think, will take issue with that. The problem, and this will be my argument, lies in the prevention of movement bit. So in relation to the existing cooperation and containment schemes with third countries, we're talking a lot about illegal pushbacks by member states and by Frontex and the crucial issue of jurisdiction that Violeta has already addressed. But the human rights obligations don't end with the member states. Containment policies in third countries and by third countries must also comply with their human rights obligations, in particular, the right to leave. Next slide, please. The right to leave is contained in a number of international documents, which I've listed on the left side of the slide. starting with the Universal Declaration of Human Rights. Article 14, which I've excerpted here, contains the right of everyone to leave any country, including his own, and then also the right to return to his country. Next slide. Protocol number 4 to the European Convention on Human Rights contains similar language, and so do the American Convention and the African Charter, and ICERD and the Convention of the Right of the Child also incorporate this right. The importance of the right to leave, next slide please, was of course quite obvious during the Cold War. Now think of the Berlin Wall, but next slide please. We're again reminded of this right's immediate relevance very recently when we saw the images from the Kabul airport. So how does the right to leave work? Next slide, please. First of all, it's a right to leave any country, including one's own, and this right applies to everyone, no matter their status. But as the Human Rights Committee has put it, it is only a right to leave for such country of the person's choice to which he may be admitted. And admission is, of course, a sovereign prerogative of the destination state. So basically, the right to leave is half a right. Without a state that permits entry, it is worthless. Now, of course, as we all know, there's an important modification, next slide, please, in the case of refugees and of persons risking torture or inhuman or degrading treatment. Once such a person reaches the border, they are entitled to protection from non-refoulement. Next slide, please. And they may also not be penalized for crossing the border in an irregular manner, for example, by relying on smugglers. Next slide, please. What does that have to do with the right to leave? Well, the right to leave guarantees access to non-refoulement and ultimately to protection. The right to leave, therefore, complements the right to non-refoulement. And of course, the right to seek and enjoy asylum, which I haven't also put on this slide. Without being able to leave, basically there is no way of reaching protection. Next slide, please. Now, unlike the right to non-refoulement, the right to leave is not an absolute right. I've copied in here Article 2.2 of Protocol 4 to the ECHR, but Article 12.3 of the ICCPR has very similar language. Basically, you see 4 justification grounds. The first is national security and public safety. The second is public order or ordre public, which is in the case of the Protocol number 4, also extended to the prevention of crime. The third is the protection of health and morals, whereas in the ICCPR it says public health and morals. And then Protocol 4 adds the rights and freedoms of others. Now, typical restrictions on the right to leave are made, for example, to enforce criminal sentences or to secure the payment of debt. Next slide, please. Any such restrictions relying on these grounds must be provided by law, and they must be necessary. So this requires a proportionality assessment. That means a balancing of the public and private interests. The ICCPR adds that the essence of the right must not be impaired. So how do these 4 grounds that I've mentioned relate to the purposes of externalization that we've reviewed at the outset of my talk? Next slide, please. Now, at first glance, each of them can be related to these purposes of restricting the right to leave. But I'll show that when we look more closely, none of them actually apply to the situation at hand. Let's start with the prevention of human smuggling. Now, you will think of the ordre public justification, the prevention of crime, because human smuggling is a criminal offense, and it's actually an international obligation to criminalize human smuggling and to also prosecute it under the Palermo Protocol on human smuggling. However, the Palermo Protocol also makes clear that any action in combating smuggling must preserve the rights of migrants. And it clarifies that the action must be directed against the smugglers, not against the migrants. So from a human rights perspective, that means that preventing departure is not necessary to combat smuggling. You can basically arrest the smugglers without containing the migrants. Next slide, please. as to irregular immigration to another country or preventing irregular entry. We know that the destination countries, in our case, the member states, are asking third countries for assistance in migration control to prevent unlawful entry. And third countries do this through travel bans, through seizure of passports, or by criminalizing and by simply de facto preventing undocumented departure. Again, we can think here of the ordre public justification. But think of the balancing that is needed. This balance has to be struck between the individual's interest in leaving the country and those of the society. But that also means that the justification ground can only relate to the country's own ordre public. This is also consistent with other rules of international law. Think of the law of the sea. Akis has already mentioned the coastal states, or it's sort of the right to innocent passage. A coastal state can interfere with this right to innocent passage in its territorial waters. For example, when a vessel is trying to leave those coastal states' waters, bearing migrants. However, this interference can only be made to protect the coastal state's own immigration laws, not another state's immigration laws. This reading is also consistent with the Palermo Protocols. As I've mentioned, the rights of migrants must be preserved, including, of course, the right to leave, and action must be directed not against them, but against smugglers. And finally, this is also consistent with EU law. There is a case in the Court of Justice called JIPA. I'm not quite sure how to pronounce it. It's a Bulgarian name, if I remember correctly. And the court there confirmed that the EU right to leave, or this right to leave derived from EU law, cannot be restricted simply to please other EU member states, so they won't be more restrictive in their visa policies. Finally, yes, of course, you can also criminalize undocumented exit and then say, oh, but we have to restrict the right to leave because we have to prevent crime. But of course, that would be a circular logic.
Nora.
Okay, next slide, please.
Nora, I hate to do this, but I want to point out that you were going over your 10 minutes. So could you conclude?
Okay, I'm wrapping up.
Right, great, thank you.
Coming to the loss of life, that's the next slide. There's of course an obligation to protect the right to life. Oops, this is my timer, indeed, sorry. However, there is also a duty to respect autonomous decisions, and the European Court of Human Rights has been very careful to make sure that states can protect the autonomy of the decision, but not prevent self-harm just because. So wrapping up, none of these grounds are actually able to restrict the right to leave any country, including one's own. And next slide, please. This is, of course, even more obvious in the case of situations at sea. Sorry, one more slide. Because they are leaving one country doesn't automatically mean entering another. Conclusion, last slide, please. What does this mean for the external dimension of the Pact? Basically, it means dressing up pushbacks as pullbacks does not just make them okay in terms of human rights law. A country of destination may restrict entry to its territory, may control its borders as a matter of sovereignty, but the country of transit or origin needs good reasons to restrict exit from its territory. It must do so by law, it must observe proportionality, and the prevention of irregular entry abroad is not a protected interest. And if this were not the case, there would not be access to non-refoulement. Thank you.
Thank you, Nora, for a wonderful presentation, which is innovative, and I've seen the let's say the body language of the audience. You will get some challenges on your argument, which I really look forward to. The next speaker is Vincent Chetaille from the Global Migration Center in Geneva. Welcome, Vincent, and you will make the connection with the Global Compacts. The floor is yours.
Thank you very much. I'm very pleased to be here and honored to be involved in this conference. And despite the short time limit assigned to speakers, I would like to express my warm thanks and deep gratitude to Philippe de Broecker and his amazing work he has done since the creation of the network. Thank you, Philip, for your dedication in our field and in advancing academic knowledge. I've been asked to talk about the new Pact and the UN Global Compact. Of course, a lot can be said given the time limit. I will only mention some selective remarks. Maybe from the very beginning, the EU Pact and the UN Compacts are different types of instruments for different audiences with different, if not contradictory, objectives. Basically, the two global compacts, respectively devoted to migration and refugees, have been adopted by the General Assembly of the United Nations in December 2018, after a long and intense process of negotiation. And the two compacts are framing the international agenda with a set of commonly agreed objectives and related actions to achieve them. So, generally speaking, the compacts are universal by nature, and they reflect a common approach among the broad number of UN member states. So the central objective of the two compacts is to foster international cooperation and global governance. And the Migration Compact does provide a comprehensive approach to achieve this objective, while the Refugee Compact is more focused on responsibility sharing. And probably more interestingly, the traditional divide between the global south and the global north has not been an obstacle to the adoption of the two compacts, because since the Cairo Conference of 1992, the divide between the global north and the global south has been a key obstacle. And for instance, it has been the reason why a UN Conference of Migration has been postponed since 1992. And finally, we have now two UN compacts. And interestingly, the dividing line during the adoption of the compact was no longer geographical and between global north and global south. If you look at the results of the votations in the General Assembly, the dividing line was between populist governments and the others, whether they are located in the south of the north. So this was a quite interesting development in terms of the broader international agenda, and also, of course, regarding the content of each compact, to bring a new momentum to foster international cooperation. On the other hand, the EU Pact, is a pure European product. It is focusing on EU concerns, and in fact, it is detailing the political priorities of EU member states. So from this angle, the EU Pact is a typical expression of the traditional Western agenda. And of course, the EU Pact is not an instrument aimed at implementing the UN Compact. This is even from some angles the contrary. There is some contradiction between the EU Pact and the Compact. Interestingly, the EU Commission communication on the new Pact has no explicit reference to on the UN Compact. So only only the package of instruments reflecting the overall Pact does a few and in passing mentions, but very brief. And for instance, the Compact on Refugees is mentioned again in passing in the recommendation on legal pathways to protection in the EU regarding resettlement. So, but of course, the content of this recommendation, of course, not of course, but even unfortunately, the content of this recommendation is still far from being a contribution to the Refugee Compact, especially given that the Refugee Compact is heavily focusing on resettlement. And from this broader angle, I mean, the European states have a major responsibility in this area, simply because 90% of refugees in the world are hosted in the global south. So clearly, the limited scope of this recommendation on resettlement will not achieve the broader and more ambitious objective of the Refugee Compact. Another striking difference when you are reading the EU Compact and then continue with the UN ones, there is another striking reference, especially for us lawyers, because regarding the references to international law, international human rights law. The UN Compact contains many reaffirmations about human rights of migrants, due respect for international law, and interestingly, there is a very important reaffirmation of the duty to respect and ensure respect for the rights of all migrants without regard to their documentation status, immigration status, and so on. And by contrast, there is no such a thing in the EU Commission communication on the new pact. So clearly, there is, of course, there are some references to international law and human rights law because this is binding. But I mean, references are very limited in number when you compare the EU Pact with the UN Global Compact. Of course, again, there are some commonalities and convergences between the EU Pact and the UN Compact. But the overall design and the objectives are very different, and again, sometimes contradictory. Rather than representing a fresh start, the pact remains in the continuation of the long-standing European policy based on containment and externalization. So, which are, for obvious reasons, not mentioned in the two UN compacts. So, key strategy carried out by the EU for several decades has been to shift protection obligations and so-called migration management onto third countries in order to avoid arrival of migrants and also to avoid the international obligations. So this is not new at all, but clearly the pact is reaffirming this general strategy. And the main components, again, are not fundamentally new. They are the usual ingredients of the containment approach, a focus on the root causes, return and readmission, safe third countries, removal, and at the border. The pact is using the language of cooperation, but cooperation, international cooperation, is conceived as a tool to achieve externalization and containment. So the tone is, the objective is the same. The tone is slightly more nuanced than it was in the past, 2 decades ago, for instance. To give some instances, the Commission acknowledges something which is quite obvious but important. The Commission has acknowledged the interests, the divergence of interests between the EU and third state, the need for a comprehensive and balanced approach and partnership, and also the importance of visa in facilitating cooperation. So there are some some changes in the tone. However, these changes are rather cosmetic because the substance and the overall design is not fundamentally different. Coercive measures are still on the table, especially the possibility to take measures against so-called non-cooperative countries, as if third countries were bound to cooperate with the EU. All states are sovereign and equal. The EU cannot decide who must be sanctioned or not, simply because they are exercising the right to refuse ratification of a readmission agreement.
Vincent?
Ratification is not a duty.
Vincent?
And third states are free to refuse such a conclusion.
Vincent, so, can I ask you to conclude?
Yes.
Yeah, thank you.
I mean, there are many other things to say about the partnership, the root causes approach, but clearly there are here the pact fails short of providing a genuine reform as such. Instead, the new package mainly reproduce and sometimes exacerbates the systemic flaws of the EU migration and asylum policy. And there is still a need to rethink migration and asylum policy and devise innovative solutions, not necessarily from the EU member states, but also taking into account the lessons learned from the UN Global Compact, because clearly there is now a gap between the UN Compact and the EU Pact, and at the international global level, the EU migration policy is part of the problem. And the EU migration policy can become the solution if and only if the EU is able to learn from its own mistakes and able to engage a balanced and equal cooperation with the other states. Thank you very much for your attention.
Thank you very much, Vincent, for giving a more global perspective on the external policies of the EU in the Pact. The next speaker is the only speaker this morning who is actually physically present in the room. We have learned how great it is that technology is, but during this conference, I'm increasingly appreciating old-fashioned face-to-face contact. So the floor is to Paula Garcia Andrade from Madrid, who will address the cooperation between the EU and third countries. The floor is yours.
Thank you so much, dear Thomas. Good morning to all of you. I'd like to warmly thank Professor De Buycker for giving me the opportunity to take part in this conference, and to the Odysseus team for making it possible. Straight to the point, one of the objectives of the Pact presented by the Commission a year ago relates to the need to reinforce cooperation with third countries through comprehensive, balanced and tailor-made partnerships addressing diverse dimensions of migration. Among them, I would like to put the attention today on asylum. Although the Commission indicates in its communication without further explanation that possibilities to enhance EU cooperation with third countries in this field are limited, the accent is nevertheless put on how working with partners also helps the EU to fulfill its obligations to provide protection, that cooperation on migration governance shall include well-functioning asylum and reception systems, that emergency and humanitarian assistance to countries of asylum hosting large numbers of refugees is a priority, and of course stresses this new importance of developing legal pathways to Europe with the aim of removing incentives to embark on dangerous journeys, and of demonstrating solidarity with third countries. An examination of the legal framing of current developments in this external dimension of the EU asylum policy and the proposed ones according to the Pact leads to two observations that I find of concern and that relate to two notions or principles enshrined in EU primary law. On the one hand, the objective of partnership in the relations with third countries on asylum in Article 78.2g of the TFEU, and the principle of solidarity that we can infer for the external relations of the EU from Articles 3 and 21 of the TEU. The first observation is that the so-called external dimension is being built mainly through internal acts. With the exception of the controversial EU-Turkey statement and certain international protection-related projects within mobility partnerships, most of these instruments aimed at cooperating with third countries on asylum are not governed by arrangements or agreements, not the result of a confluence of wills between the Union and the partner country, but are instead established through internal measures, unilateral EU acts without the involvement of partner countries. This is the case, as you know, of financial and technical assistance to reinforce the capacity to provide protection through, for instance, regional and development protection programs, which is a kind of instrument which is not even formalized in a legal act or an informal arrangement, and in which the partnered representatives do not even take part in the steering committees of these programs. Resettlement, we found references in financial instruments of the EU supporting the implementation of EU and national programs and are also the object of recommendations by the Commission to Member States, but there is no evidence of formalized engagement whatsoever with the country of asylum. It can be argued that the design and operationalization of this external dimension is therefore following a strict externalization approach in formal terms, through which internal EU acts are having effects on third countries rather than responding to a formal logic of partnership, of cooperation, which is the objective assigned to the Union in Article 78.2g, and which is associated, as argued by Lavenex, to a voluntary form of cooperation among equals, presupposing agreements between them, pursuing common goals based on cooperative governance, common interests. So this seems to question the consideration of the interests and needs of countries and regions of origin, the efficiency of institutional capacity building, and as well the promotion of international solidarity. We witness, in fact, a contrast between the consultation which is typical of international relations on control-oriented aspects, such as readmission, with the unilateralism on asylum issues. This characterization as internal acts, while being at odds with the concept of partnership in the treaties, responds, however, to the features of the competence conferred by EU primary law to the Union to establish cooperation with third countries. We were surprised in Lisbon when this provision, Article 78.2g, not exempted from criticism for several legal and political reasons, conferred on the Union an internal competence to establish cooperation with third countries through internal legislation. We see now this is the reality, and although we can deduce clearly an implied external competence from this provision that allows the Union to conclude international agreements on asylum, this external competence has not been used yet. The second observation we can infer from the analysis of the current and future developments on internal cooperation on asylum by the EU is the facultative nature of Member States' participation in these instruments, which represents a further illustration of the increasing place that soft law is having on EU migration and asylum policies, and which particularly questions, in my view, the achievement of the objectives of some of the EU competences on asylum. The example, again, of RDPPs as an instrument to provide financial and technical assistance to its partners is quite telling. Member States take part on them voluntarily. Other components of this external dimension, such as resettlement, promotion of other legal pathways to protection, are organized at EU level through recommendations, encouraging the participation of Member States. Even the proposal on a regulation on resettlement, a legally binding act of EU law, contains only mandatory provisions on the procedures to be followed, on the standards, but not on the national participation on EU resettlement plans. Another example, EU-Turkey statement, an arguably non-legally binding instrument. Even the statement regarding the critical situation in Afghanistan, issued by the Extraordinary Home Affairs Council on the 21st of August, as both Philippe and Thomas have highlighted, indicates that support could be provided in the form of resettlement on a voluntary basis. So the political impact of the union action, of this soft union action, is rather evident. On resettlement, it is clear. Voluntary contributions, as observers have pointed out, undermine the significance and credibility of the instrument, lead to uncertain long-term impact and a lack of predictability for the partners implementing resettlement. So the question to ask, in my view, is which intervention should the union have in this field? In spite of the benefits that soft harmonization may entail, in the words of our colleague Luc Leboeuf, and the evident political will now of member states against bindingness in this field, I'm sorry, but I think it is interesting to ask the question whether the union should be binding, should be requiring member states to participate in these measures, whether there are legal arguments against the recourse to soft legal acts in this EU expression of international solidarity. The EU can certainly exercise its competence with the effect of binding member states. That's clear, either adopting internal legislative acts or concluding international agreements according to Article 218 of the TFEU. It seems, however, difficult to argue that the EU has a duty to bind member states to take part in these instruments of cooperation with third countries, since, as you all know, there is no obligations for states under international law to alleviate the burden of countries of asylum. The only references to responsibility sharing in an internationally legally binding instrument appear in the preamble of the Geneva Convention. An exception could lie in the possibility to turn the discretionary nature of resettlement into a mandatory act when a state is bound to observe primary norms of international law, such as the prohibition of torture, non-refoulement, or other international humanitarian obligations in situations of post-military intervention in another country. This was argued by De Boer and Sick in 2014, and thinking of the current situation in Afghanistan, this could be the case of a state that by military intervention or occupation then lives and has certain protection obligations, but which are limited to specifically protected persons, of course. We can discuss this later on if you wish. However, if in general terms an obligation to express international solidarity is difficult to sustain, some alternatives might exist under EU law, and I would like to raise them very briefly to end my contribution. A possible argumentation in favor of opting, if possible, for mandatory rules binding member states in this field could lie in the duty of external solidarity on asylum that, as our colleague Violeta Moreno has argued, could be inferred from Article 3.5 and 21 of the TEU. This leads to a duty to opt as far as possible for those measures that favor cooperation with third countries on asylum. I think this argument could be combined with the concept of common policy in order to defend that it would be preferable for the EU to bind member states to participate in these measures instead of just encouraging their voluntary participation. Otherwise, the duty of external solidarity and the obligation to develop a common policy on asylum could not be realized in the EU. Another argument, I think, could lie in internal solidarity. I wonder whether an unequal participation of member states in external solidarity might negatively affect member states' capacity to implement engagements on internal solidarity, an evident obligation according to Article 80 of the TFEU. This could constitute an additional sign of the intertwinement between the external and the internal dimensions of the EU asylum policy, as it clearly arrives on the migration aspects. And finally, a further argument relates to the formal act of EU law used and can be found in the material limits to the use of soft law that would make preferable again to resort to legally binding acts. Resorting to the adoption of recommendations by the Commission, as it has done on resettlement and complementary pathways, who has, of course, this general power according to Article 292 of the TFEU, can question the institutional balance of the decision-making procedure foreseen in Article 78, which confers a legislative power to the Parliament and the Council in this field and dictates the ordinary legislative procedure as the adequate decision-making path. This has been the traditional position of the Parliament against the use of soft law. The authors of the treaty conferred on the EU a legislative power to adopt the objectives of the asylum policy, which therefore reflects a certain institutional balance that is being disrupted when the Commission adopts recommendations, together with other principles, such as the democratic one, of course, when those objectives are pursued through different decision-making procedures. And to conclude, in some primary law, enables the Union to develop an external action in the field of asylum quite more intense than the one developed up to now, and to be framed by instruments that should be, according to primary law, the expression of partnership and solidarity. So if the EU is not assuming the role expected from it as a key actor in the international protection system, we all know the reasons. But the obstacles and limitations clearly do not lie in the EU constitutional framework. Thank you so much for your attention.
Thank you, Paula, for taking us through the European constitutional aspects of externalization, and that was very enlightening. We began this panel 10 minutes late, so I asked permission of Philippe to go 10 minutes over the final time. So that means we have some 20 minutes for exchange and discussion. I first want to ask whether there are questions online.
Yes, Thomas, we have one question online. And a question posed by Ms. Eva Zavala for Professor Moreno Lax. The question is, if and how, under which scheme, EU member states that provide funds, vessels or equipment to third states for migration control purposes can be held responsible when violation of human rights occur at the border by third states' border guards. Thank you.
Thank you. I propose to collect a few more questions. I saw two fingers. The first was Achilles Cordes.
Thank you very much. I have a question for Professor Markard. As I understand your analysis, can I get the conclusion that if you are at the border and you claim asylum, you say, I want asylum, you make the visa system smooth worldwide. And if this is the case, then do we have evidence of international practice, state practice or judicial practice of such a sweeping development?
Thank you. And the other question is from Boldinaj.
Thank you. I will address Nora's presentation in my role as the advocate of the devil. Nora, you say that the balancing of the individual interest and the public order only relates to the country of departure and not the country of destination where the person wants to go while leaving. Now, let me challenge that. And what I raise here is that can't the country of departure and the country of destination form an interest community? And therefore, can they not agree that the ordre public of the destination country qualifies equally with the ordre public of the departure country? And just to give you one example, Schengen is based on that idea. When you prevent the departure of someone who is sought after in Spain, and you prevent the departure from Slovakia, then Slovakia is in effect implementing the ordre public of Spain. And I don't think that this uniting of the public orders of two countries need to be limited to the Schengen countries. I think that any two countries in the world can decide that they have shared public orders in certain respects. So that's the question. Therefore, can the EU not argue that we have agreed with Libya, we have a common public order, they do a service to us as we do to each other? That was the devil's advocate. I want to use the argument, of course, of the right to leave. Just I want to perfect it.
Thank you.
With your help.
Thank you. I've now two more questions, and I guess that's the max we can handle. One is Ulrike Brandl.
Thank you for the excellent presentations. I also have a question to Nora and also to Violeta, going in the same direction. I remember we discussed the right to leave with Nora a couple of years ago, and my intention was always to create an obligation of other states to admit persons, because the right to leave is uncontested, but in which situation and when do states have obligations to facilitate that persons can exercise the right to leave? This is also a question of jurisdiction. So I'm keen to hear solutions. I have, of course, the situation in Belarus, in Afghanistan in mind, but in other countries as well. Libya was mentioned. We discussed Libya a couple of years ago. So I see some practical problems, but also from legal theory interpretation. So it's quite an interesting question, I think, the question of jurisdiction and the effectuation of the right to leave.
Thank you. There's a final question of a gentleman. I'm sorry, I don't know your name, but
my name is Jérôme Vignon from Jacques Delors Institute. Dear Thomas, I'm sorry because it is a question, or rather a reaction to your presentation, which I venture. I'm not a lawyer, but more familiar with historical and geopolitical perspective, and I might disagree with your presentation. First, I don't believe that in the case of Afghanistan, the EU might be considered as contributing to the roots of the situation. There might be events like this and other still to come, where the EU is faced with a geopolitical situation on which it has no grip, but it must react. Second, you ridiculed the very low share of Afghan people taken in resettlement in Europe, but I don't think that this comparison is really relevant. I belong to a country, and Germany would say the same, and Italian and Spain, for example, and Sweden, where until 2015, there have been almost no Afghan people receiving a protection in this country. So we should not just compare with other nations like Pakistan or Turkey or Iran, but we should compare with the history. There was no tradition of granting asylum to Afghan people, and now there are a number of Afghanese people. There is a diaspora of Afghan people in Europe, and this diaspora is very vocal and usefully today. And thirdly, on return, you also ridiculed the return policy of the Pact, but the question today is not so much whether this return policy would be useless in the point of Afghanistan today. It is more about suspending the return decisions which have been already taken against Afghan people in Europe today, and it is the case that we are on the course of suspending those decisions.
Thank you. I propose I give the floor first to Violeta and Nora, and then to the other members of the panel. So, Violeta.
Thank you for the very interesting questions. So to respond to the one regarding when an EU member state or the European Union might be held responsible for the provision of funding and equipment and so on to third countries, I would say that under the Charter of Fundamental Rights, Article 51, in combination with one of the substantive provisions, be it, for example, Article 19, the non-refoulement or collective expulsion provision, or Article 18, the right to asylum, or Article 4, the prohibition of torture, will be activated whenever the situation is considered to fall within EU law. And I would say that any funding, EU funding that comes from the EU budget, including the trust funds, it's subjected to the observance of the relevant provisions in the treaties regarding development cooperation and humanitarian assistance. I mean, that's regulated verbatim, right, in the TFEU, and it's subjected to the hierarchy of European Union norms, including the Charter of Fundamental Rights. When countries would act unilaterally, as it has been claimed Italy does vis-a-vis Libya, I would say that the functional jurisdiction approach would entail that we take a holistic look at what is being done. And if you buy into my argument on the functional approach, then whenever there are sufficient elements to establish an exercise of public powers through either executive, legislative or judicial action or omissions by a state, that would trigger its responsibility. And if you do not buy into my argument, there is plenty of case law anyways from the Strasbourg Court on decisive influence. So for example, the Cyprus cases where Turkey was condemned precisely for facilitating the Northern Cyprus occupation through a local administration, was determined to be an exercise of jurisdiction on the part of Turkey through its decisive influence that it was exercising through funding, equipment, training, and so on. And the same applies to the Transnistria case law concerning Russia in Moldova, or the Chiragov ruling, which is one of the most recent concerning Armenia. So if you are curious to know more about that, I would go for the decisive influence case law of the court. And in terms of jurisdiction and the right to leave, the question that Ulrike has made, my argument that I've made elsewhere is that the right to leave applies not only vis-a-vis countries of origin, but as Nora has said herself, also vis-a-vis countries of transit, and for me at least, also countries of destination. I developed the whole argument on the opposability of the right to leave vis-a-vis countries of destination in accessing asylum in Europe. And sorry for the self-promotion, but I will not have time now to provide a holistic response. So if you would want to discover the full argumentation, it's already written up. But the bottom line is that whichever country would exercise jurisdiction through, for example, legislation on visas or carrier sanctions or interdiction at sea, or through any other non-entrée measures, that would trigger the action of all of its international human rights responsibilities within the ECHR. And if the country itself has ratified the Protocol 4, where the right to leave is contained, that would also trigger obligations under the right to leave. So the right to leave is not only of relevance for the country of origin, but also to any country which can be determined to exercise jurisdiction. And if jurisdiction can be exercised extraterritorially, it means that obligations under the right to leave can also be triggered extraterritorially as well. Thank you.
Thank you, Violeta. Nora.
Yes, thank you for your questions. I'll start with Akis Papastavridis' question. You asked me whether if I'm at the border and claim asylum, I can make visa systems basically moot, and whether there's any international practice to support this point. I would say yes to both. That's the short answer. Of course, international practice in Europe starts with the Züring case and comprises the Article 3 as non-refoulement principle jurisprudence. The longer answer is, of course, if you're at the border, you benefit from the right to non-refoulement, which is a very limited right, which is, however, limiting the state's sovereign prerogative at the border of admitting whoever they wish. This person will, deriving from Article 3, and the same argument can be made for Article 33 of the Refugee Convention, it will have, deriving from Article 3, procedural rights, the right to have a remedy with suspensive effect, the right to have legal counsel, the right to have a translator, and so on and so forth. Rights which I would argue will usually require at least a temporary presence in the territory of the state that has to respect these obligations. Definitely, it's very difficult to see how these obligations could be observed at sea. And if the right to non-refoulement then ends up applying, so if the person is right to seek protection, then there are again limitations of, can you refer that person to protection elsewhere and under which conditions and so on and so forth. So I condensed this for the purposes of my presentation into a very short point. You can overcome the no entry rule through non-refoulement, but of course things are a little bit more complicated in practice, but they're well supported through international practice. As to Boldushar's point on joint ordre public, if you will, I think you're making a very, very interesting point here. At the same time, the example that you gave of, for example, the arrest warrant is one where the person will be apprehended and then turned over to another state for prosecution purposes. So the restriction on the right to leave is more an effect of this than the purpose of the measure. Now, still, you could say it's a restriction of the right to leave. It needs to be justified. In this case, and sort of also looking at the jurisprudence, I think arguments can be made in support of the point that the ordre public of another state can be taken into account. I would still argue, though, that an integrated reading of international obligations would mean that you cannot, sorry, I'm missing the word, limit the essence of the right or touch the essence of the right by basically making it impossible for anyone to leave in the direction of protection. This is what's also required by the obligation of non-refoulement and the sort of the role that the right to leave plays in relation to this right. So we have sort of a succession of rights, right? We have the right to leave, we have the right to non-refoulement, and we have the right to seek and enjoy asylum on the other side of the border. So that would be my argument. And I have to say, though, I haven't mentioned the article that I based my talk on. I've developed this argument in much more length in the European Journal of Human Rights in 2016. But coming to Ulrike Brandauer's point, whether this also creates obligations on the receiving states. I have in that article also made an argument that this may be due to complicity, even if there's no direct jurisdiction, so that receiving states might not just violate their duties to non-refoulement, but also their duty to respect the right to leave. And I think I'll leave it here. Thank you.
Thank you, Nora. You cannot see, but I could see that there's people here burning to respond. But because I'm tasked with guarding the order public of this meeting, I will not give them the opportunity to do so. Thanks. I will ask the other speakers to briefly reflect on the things that were raised during the questions. Akis.
Thank you so much. To be frank, I don't have anything. There was no question addressed to me, but I don't have anything to add. So I will waive my time to the other speakers if you want, Vincent and yourself, if you want to make comments. And thanks again.
Thank you. The other speakers will also have to be very brief, but nonetheless, Vincent.
Thank you. Maybe two brief remarks on the right to live, because this is clearly a foundational right when it comes to migration. First of all, in terms of the scope, it is important also to remind the case of the European Court of Human Rights, Stamos versus Bulgaria in 2012, because in this case, the European Court was very clear. A travel ban, adopted by the country of departure, travel ban designed to avoid violation of immigration legislation of the country of origin is a violation of the right to live in the country. So clearly, this is important to acknowledge that this point alongside what Nora said before, because there is clearly a clear divided line between departure and admission, between the right to leave and admission. The lack of a second remark, it's common to say that this is a half right and so on. Yes and no, because my conviction is that international law today, at least, and because for a long period of time, free movement was a rule, but today, since at least the last century, clearly there is a normative disjuncture between exit and entry. As a result of this disjuncture, there is no general right to enter. However, the right to leave any country is supplemented by a specific right to enter, because this is this is not only a question of pure sovereignty. Of course, non-refoulement is part of the picture, but there are many other duty related to admission, not only procedural ones, substantive ones. Free movement agreement, of course, EU is a well-known example, but in reality there are many others, and especially in Africa, but in other continents. So clearly here there is a right to enter following a free movement agreement, but many other rules are governing admission. So even if under human rights law there is no general right to enter, there are specific entitlement, specific right to enter based on various, bilateral agreements, regional free movement agreement, family reunification duty, and so on, besides non-refoulement. And last point, right to live is a truly universal right binding all states. This is, I did a study on the customary law nature, and I realized that, every single UN member states have ratified one or several treaties acknowledging the right to live. And clearly, the right to live is binding not only at the universal level, not only for all states because of treaties, but also a part of customary international law. And I will stop.
Thank you very much, Vincent. Paula.
It's okay, I know we are late.
Okay, you waive your right to speak. Okay, then I'll wrap up, and in doing so, I will also respond to the last question, which was directed to me. I think that essentially we have tried to and of course that's not just in this panel, try to see what lessons the EU has learned from 2015, and let's say that the EU has still some distance to go on that point. And I think this panel has impressed me by indicating how deep the reflection, the reconsideration of EU law and policy will have to go. If that really happens, because it requires rethinking of jurisdiction, of human rights notions, including the right to leave, the law of the sea. It requires aligning the pact with the two compacts, where Vincent indicated how big the gap between the two is. And Paula has indicated how deeply ingrained into the EU constitutional system the internal nature of externalization is, and so the non-cooperative and the what I would call coercive nature of externalization is. All these are problematic, and the situation of Afghanistan and the idea that this might lead to a crisis also in Europe makes clear in a very concrete instance that these are not merely theoretical, detailed legal issues, but actually impact the future of this policy, and as people has pointed out yesterday, of the EU potentially more broadly. We may have some time, but now it's time for coffee, and we reconvene at 11.